The Fourth Amendment by yours truly, Brian Hicks. The Fourth Amendment states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. To have standing claim to protection under the Fourth Amendment, one must first demonstrate an expectation of privacy, which is not merely a subjective expectation in mind, but an expectation that society is prepared to recognize as reasonable under the circumstances. The ultimate goal of this amendment is to protect people's rights to privacy and freedom from arbitrary governmental intrusions. The Fourth Amendment is a part of the Bill of Rights, and was adopted in response to the abuse of the writ of assistance, a type of general search warrant issued by the British government and a major source of tension in pre-revolutionary America. By December 15, 1791, the necessary 3/4 of the states had ratified it. On March 1, 1792, Secretary of State Thomas Jefferson announced the adoption of the amendment. In the court case Mapp v. Ohio, Dollery Mapp was convicted of possessing obscene materials after an admittedly illegal police search of her home for a fugitive. She appealed her conviction on the basis of freedom of expression. The court brushed aside the First Amendment issue and declared that all evidence obtained by searches and seizures in violation of the Constitution is, by the Fourth Amendment, inadmissible in a state court. Mapp had been convicted on the basis of illegally obtained evidence. This court case placed the requirement of excluding illegally obtained evidence from court at all levels of the government. The decision launched the court on a troubled course of determining how and when to apply the exclusionary rule. There are exceptions, however. In the topic of cars, the use of a narcotics detection dog to walk around the exterior of a car subject to a valid traffic stop does not require reasonable, explainable suspicion. In the topic of schools, school officials need not obtain a warrant before searching a student who is under their authority. Rather, a search of a student need only be reasonable under all circumstances. Also, for the topic of persons, when an officer observes unusual conduct which leads him reasonably to conclude that criminal activity may be afoot, the officer may briefly stop the suspicious person and make reasonable inquiries aimed at confirming or dispelling the officer's suspicions. On the topic of homes, searches and seizures inside a home without a warrant are presumptively unreasonable, but is reasonable if an officer is given consent to search, if the search is incident to a lawful arrest, if there is a probable cause to search, and if the items are in plain view. The Fourth Amendment protected individual rights of A. Illegal search and seizure, B. Probable cause, C. Warrants, or D. All of the above.